I have lost hundreds, if not thousands of properties over the years that I've spent hundreds and thousands of hours negotiating. Do you need to have a conveyancer or solicitor check through the actual contract of sale prior to signing it if you're buying a property in Queensland or Perth? Before I answer this question, this is not financial advice. This is general disclaimer, consult with your accountant, financial advisor, lawyer, etc., etc. What a very important thing to understand is in Australia, every single country has different laws, processes, and procedures for buying a property. As an example, in New South Wales, you really need to get a conveyancer solicitor to review a contract to sale generally before you sign it. You don't have to, but it's recommended in New South Wales very commonly, because in New South Wales, you do not have standard clauses such as a finance clause or a pest and building inspection or due diligence clause in a contract to sale of New South Wales. However, if you're buying a property, let's say in Queensland or WA, and odds are if you're buying a property with myself, with our assistants, then it would likely be at the moment either in Perth or Queensland or maybe even in Adelaide. We do buy in New South Wales sometimes, but at the moment it's mainly Perth and Brisbane, as you probably know, because of the market growth and rents, etc. 99% of the clients that we generally deal with do not have a conveyancer solicitor review the contract prior to signing it. And before you freak out, the reason why that is because in states like WA or Queensland, you have what's called a finance clause, a pest and building clause, due diligence clause. The contracts that we are when we help a client buy, they're not what they call unconditional. It doesn't mean that even if a client signed for a property right now, they've basically got within 21 to 28 days where if anything did go wrong, if they didn't get finance approval, if the pest and building had major issues, even if technically they just changed their mind when something happened and didn't want to buy it anymore, they could pull out under those clauses within 21 to 28 days and get the deposit refunded in full. Now, the deposit in Queensland or WA is usually between $1,000 to $5,000. Most of the time it's $1,000, could be $3,000, $4,000, but the max deposit you're gonna put down is $5,000. Even if there's a property, let's say it's a very good deal, we've gone through 3 or 4 properties, you and I together. We've gone through 4, there's one that jumps out and you really love it and you wanna buy it. It is fine to sign what they call, in WA, they don't even call it a contract to sell, they call it an offer and acceptance documentation. In different states, they have different terminologies as well. They've got cooling off periods, they've got finance clauses, they've got pest and building clauses, they've got 1,000 different clauses. If you're buying your first or second property, you're probably not gonna know all this stuff, so please don't pretend that you do, especially if you've maybe bought one in New South Wales. Anyone that's bought a property in other states like Victoria or New South Wales or Northern Territory, if you haven't bought in WA and Queensland, and if you are buying right now, I would highly recommend go back to zero, pretend you don't know anything. Even if you bought in New South Wales, you haven't bought in WA, so you don't know anything about WA. So just pretend you don't know anything right from the get-go. But we are there to guide you through that. This video is there to explain a little bit about it. I'm sure I'll be explaining a little bit about it myself or the team. But this is to give you the heads up that you don't always have to get a conveyancer solicitor to check through the contract to sale. Sometimes it is detrimental to the actual property negotiation itself. We might have a property that only lasts for 48 hours. I might present it to a client on Monday, and then yes, they have the opportunity to chat to the wife, chat to the family, whatever it is, have a bit of a think about it, have a sleep on it if they want to, and then if they're interested in coming back to me the next day and say, yep, we would like to proceed, or we run through a few final questions, and then if they are happy to proceed, then we immediately, the most important thing is completing the DocuSign offer and acceptance or contract sale immediately to try to wrap up the deal to actually secure the property for that 21-day period. It's very important to complete it as quick as possible, that we basically will get a property negotiated at a price, and it will be verbal handshake agreement, and handshake agreements don't always last. Verbal agreements don't always last. Just the other day, we picked up a property, multiple properties for $299. It was verbally agreed that the seller agreed at $299, and because we were slow with the contracts of sale, one of the clients wanted their conveyancer to check through it, which they didn't eventually, but that slowed down like 24 hours from them actually getting the actual contract signed. Other offers came in the meantime. the seller received offers of 320 plus 320, so $20,000 more. And because they've verbally agreed to sell for 299, but there's nothing in writing yet. They haven't signed anything. So they can technically say, oh, sorry, well, you didn't act quick enough. We agreed to sell for 299, but in the meantime, it's not our fault that a higher offer came in. Every second that the offer and acceptance document or the contract to sell, every second that it's not signed, you risk losing the property. I have lost hundreds, if not thousands of properties over the years that I've spent hundreds and thousands of hours negotiating just because of a delay. Just because of a delay with a conveyancer. Conveyancer will try to buy a property on Friday. Oh, my conveyancer can't check it till Monday. Well, you've lost 2 days there. And then by the time they check it on Monday, they gotta walk in the office, grab a coffee, grab the lunch, all that kind of stuff. And they can't check it till Wednesday or Thursday. So they can't even get it, check it till Friday. So you lose 3 days. So basically, no matter what, you'll be able to get the deposit back out of buying thousands and thousands of properties. We've never ever had anyone lose an initial property deposit of $1,000 or $3,000 or $5,000. If someone did lose it, I've said it to themselves, if anything did go wrong, I'd refund you the $1,000 myself. I'd pay for it out of my own bank account if that ever did happen. There is no risk when you're buying with those clauses, and we put the finance clauses and the pest and building clause in there to protect you. Further to that, if you have bought a property in, let's say, Perth, or if you haven't bought a property in Perth or Queensland, if you've only bought a property in New South Wales as an example, then if you have a conveyancer in New South Wales, or if you have a conveyancer in Victoria or whatever, any other state, you might not even be able to use them anyway. And the reason why that is because every single state has different legislation. Every single conveyancer has to generally be usually registered in that particular state, competent in that particular state. So usually I speak to people every single day and they said, oh, well, I've got a family conveyancer in Victoria, and I'm going to use them. And I say, okay, well, you're free to use whoever you like. It's completely up to you. They speak to them, they waste 3 days speaking to them, and they say, oh, they can't actually do WA law because they don't know WA legalities. And then they have to change over and use our recommended conveyancer solicitor anyway. I would recommend coming in with an open mind, resetting back to zero, and trusting in the process and pretty much taking it from there. Again, not financial advice. You're free to do whatever you like. You don't have to technically get your conveyancer solicitor to check through the contract because there is no risk involved. You could sign it today, you could change their mind, and that has happened. People have said, oh, I spoke to my wife or husband last night, they really changed their mind, they no longer want to invest, we want to pull out. Okay, no problem, you pull out. You don't even put down the deposit. The initial $1,000 to $5,000 deposit, even if you sign a contract today for a property, let's say I call you right now, we go through a property today, and it's an amazing deal, you want to buy it, even if you sign a contract today, via DocuSign, you generally don't even have to put down the initial holding deposit between 5 to 7 days after that. By that time, you would have had another 5 to 7 days before you can put down the deposit anyway. But again, if anything were to go wrong, you'd have up to 21 to 28 days to pull out to get that refunded. If it came down to the wire and let's say the finance wasn't approved and you're at day 20 and it's 21 days, it's no big deal. Don't freak out. We can just request an extension for another 2 weeks. 99% of the time, they'll just grant the extension. So then if the extension happens and then it goes past the 21 to 28 days and then you still don't get financed because you got an extension, you still get the deposit back as well. So there is no risk. Hopefully this video goes to all the clients that are coming on board, or even just anyone that wants to learn a little bit about WA and Queensland, and just to not freak out as much. Trust in the process, we'll get you there. Have an amazing day. Hope this video helps. If you have any questions, comment below, send us an email. Chat to you soon. Thanks a lot. Bye.